Greetings and welcome to Understanding Legal Terminology in Contract Law with definitions, illustrations, and examples. And before we get started, I just want to remind everyone this is strictly for the education and entertainment purposes of this YouTube channel and broadcast, not to be used, misused, or misconstrued for anything legal, lawful, business, personal, private, tax, financial, or otherwise. So please don't do this at home. That said, let's get started. So we're taking this from the restatement of contracts, which was brought to us by our good friends at the American Law Review or American Law Institute, and they're happy to clarify some of the terms and usages of terms for the legal field so that everyone's on the same page, so to speak, when it comes to using terminology. That said, it behooves us to learn that terminology because it's the one that courts default to, presume applies, and typically that's been accepted across businesses, also through other things like the Uniform Commercial Code, etc., and statutes. But contract law goes a lot deeper than that, so let's get through that first with this overview of what we'll be looking at here. We're first overview of contracts defined. We'll see how the restatement really looks at the definitions of contract and the terms related to it, like promise, promisor, promisee, beneficiary. We'll also go over agreements and bargains, how promises may be made, terms of promise, agreement, contract, and formal contracts. Those are usually the statutory type. Also, voidable contracts, ones made by parties that might not be able to be held legally responsible, and unenforceable contracts. So let's get started. And just to also mention, here, let's see what's going on here. Okay, here's an introductory note and the purpose of this presentation. Words often have different meanings to the speaker and to the hearer. Now, most words are commonly used in more than one sense, so the definition makes it possible to avoid circumlocution in stating rules. So, speaking in circles, words used have connotations that are familiar to the legal profession. So, some of these words that we use in terms here have connotations that are also familiar to the legal profession. Where a word has multiple meanings, one has been selected and then defined. So this is one of the jobs the restatement had. And the operative facts in legal relations appear in succeeding chapters. But we're going to go over a lot of stuff on this one, so let's get started. And I also want to remind everyone that we do have, I believe, the talking chat should be enabled. So if you type something in the chat, it will pipe up here right into the live stream with text and voice to bring attention to
The
questions.
prompt says, hit the like.
Yes, indeed. Questions, comments, or any other kind of inclusion you want to do here because we want to keep this interactive. And at the end, we're going to have a very special surprise and a rare treat, so stay tuned. All right, so section 1, and this is coming again from the Restatement of Contracts, written by our fine friends over at the American Law Institute that took it upon themselves to so graciously break down all the little splittings of hairs and finally defining all the terms that will be used in contract law. So I guess salute to them for this fine act of generosity they've done on our behalf. So that said, let's learn about what they've done here. With a contract defined, the definition is a contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. So performance, breach, enforced by law. Contract may also refer to resulting legal obligations or entire complex of legal relations, but also may consist of a single promise or mutual promises. Any number of persons or promises may be involved, so number of parties. promises need not be made simultaneously to constitute a set. Well, let's break this down further now. So we see all these open-ended things here with defining the contract. And to make it more difficult, there's other meanings that do not apply in this whole application here of contract law. For instance, there's synonyms for agreement or bargain. These are different terms. So a contract is not a synonym for these. These are other meanings and other applications. Perhaps it is, not in this restatement of contracts. So it may refer to an effective agreement, not in the case we're talking about here. The word contract may also refer to acts, documents, or legal relations, but mostly not the ones we're going to discuss here. Now, what contracts do have is remedies. There's damages, restitution, and specific performance. Also, recognizing or denying rights, privileges, or powers. This is what the contracts have as remedies, and see Chapter 16 for direct rule. We're not going to go that far, but I think this word restitution is something that deserves a little bit deeper of a dive. So I think this behooves us to visit Black's Law Dictionary and look at exactly what they mean by restitution, since we're diving in on these formalities. And let's see here. Well, here we got restatement, one of several influential treatises published by the American Law Institute describing law in a given area and guiding its development. The restatements use a distinctive format of black letter rules, official comments, illustrations, and reporters' notes. This we'll be going over. Although the restatements are frequently cited in cases and commentary, a restatement provision is not binding on a court unless it has been officially adopted as the law by that jurisdiction's highest court. Restatements have been published in the following areas of law: agency, conflict of laws, contracts, which we're going over right now, employment law, foreign relations law of the United States, judgments, law governing lawyers, property, restitution, which we're defining right now, security, suretyship, and guarantee, torts, we've gone over this one too, and trusts as well, and unfair competition, also termed restatement of the law. All right, enough on that one. Let's get to restitution. This is a term that comes from the 13th century, a body of substantive law in which liability is based not on tort or contract, but on the defendant's unjust enrichment. Wow, see unjust enrichment. Well, we're going to have to do that too. Number 2, the set of remedies. So we're talking about remedies here, restitution, associated with that body of law, in which the measure of recovery is usually based not on the plaintiff's loss, but on the defendant's gain. That's our unjust enrichment. And there's compensation, damages, return, or restoration of some specific thing to its rightful owner or status. That's restitution. Compensation for loss, especially full or partial compensation paid by a criminal to a victim, not awarded in a civil trial for tort, but ordered as part of a criminal sentence or as a condition of probation. Restitution. So this becomes contractual, believe it or not. So that's from sentencing and punishment, but we need to see a little bit more about this unjust enrichment. Let's find out about that, because it's referring us to this word, so we need to find what they mean here. And let's see here. Wow, we must be on something else. Let's see here. What are we on here? We're on trust. Holy goodness. Yeah, we are. So we need to find unjust enrichment. It's going to be further down here. No, we just passed it. Bear with me here. This is a scanned document here. Sometimes we get lucky. Not this time. But as we go through here, we sometimes come upon some serendipitous definitions that make it even all the better for taking the deep dive. And here we're trying to find unjust. We're getting close. Unrestricted, unreasonable, unqualified, unlawful. There we go. Unjust enrichment from 1897. So this is rather recent. the retention of a benefit conferred by another without offering compensation in circumstances where compensation is reasonably expected. So this expectation comes upon a lot in contract law here, where you could have, even if it's not expressed, that there is a reasonable expectation of some compensation. 2, a benefit obtained from another not intended as a gift and not legally justifiable. That's unjust enrichment, for which the beneficiary must make restitution or recompense. Nice. 3, so this is just from a benefit obtained from another not intended as a gift. It's unjust enrichment. All right, 3, the area of law dealing with unjustifiable benefits of this kind. So there we go. We have unlaw, a violation of law, an illegality, or 2, lawlessness. All right, enough of this. Let's get back to the presentation. Thanks for accompanying me on that deep dive. Let's proceed. Okay, so now we've seen where the remedy comes in here as restitution. This is a remedy that could be ordered outside of the civil or contractual court here. This could be something that's done because of a criminal act. And then we have varieties and binding. Well, first let's go over these operative acts. So we have the other meanings that do not apply here. We have operative acts that do. The other acts that beyond promise may be essential. So other acts to be a contract may be beyond simple promises. Consideration may be required depending on, of course, if it's a statutory or a formal contract, and depending on if it's under Uniform Commercial Code, but there's more on Section 71. We won't be getting those details today. And the delivery required for contracts under seal, which is also statutory in most cases. So these are operative acts that would also define a contract. And then there's the varieties in the binding of the contract. Some are voidable, unenforceable. There's also some that are formal or informal. You have to pick one, either voidable or unenforceable. Then there's also another choice you'll make of formal or informal. Another choice you'll have to make, it's either express or implied. Then another choice of either unilateral or bilateral. Binding assumes full capacity, no fraud or illegality, or someone that's not of legal age to contract. Okay, now let's look at some of these illustrations that are part of the restatement in contracts defined. So the key points, well, let's look at the illustration first. Party A orally agrees to sell land to Party B. Party B orally agrees to buy the land and pays $1,000 to Party A. The agreement is unenforceable under the statute of frauds. Party B's right to restitution of the $1,000, however, is governed by the same rules as if the agreement were enforceable, though, because Party B has the right to recover the $1,000 paid if Party A refuses to convey the land, because that was an agreement, but not if A is ready and willing to convey. See Section 140 and the provisions on restitution. All right, by virtue of this indirect recognition of the duty to convey, the agreement is a contract. See, so that duty, that reasonable expectation because of the agreement, it becomes a contract here. So let's look at the key points here. Party A orally agrees to sell land to Party B. So makes that offer. Party B pays $1,000 to Party A, accepts, and unenforceable under the statute of frauds, though. But Party B can recover that $1,000 if A refuses to convey. So even though this is not enforceable under statutes of frauds, it can still be enforced by other provisions here. Party B cannot recover from A, however, if Party A is ready and willing to convey that land. And the indirect recognition of duty automatically makes it as if that contract exists in the eyes of the law. So now we're on to Section 2, the promise, the promisor, the promisee, and the beneficiary. So
Sawyer Stash says it's the oral agreement equals contract.
Exactly. They could be oral, implied, expressed, conscious, unconscious. There's very many varieties is the key here. These are varieties of contracts. Let's see, that was the previous one here. We have varieties: voidable, unenforceable, formal, informal, express, implied, unilateral, bilateral. The binding assumes full capacity, though. That's key. So yes, indeed, oral do stand. All right, so now we have these different terms. Again, we're on section 2 now, the promise. Promisor, promisee, and the beneficiary. The promise is a manifestation of intention to act or refrain from acting in a specified way, so made as to justify a promisee in understanding that a commitment has been made. So made as to justify. So this is your reasonableness here, right? A promisee in understanding that a commitment has been made. So then there's 2, the promisor. This is the person manifesting this intention. So there's a promise made by the promisor. He's manifesting the intention. The promisee is the person to whom the manifestation is addressed. And then the beneficiary is where performance will benefit a person other than the promisee. That person is the beneficiary. So the beneficiary is the one that benefits for the promisee, if there's one so deemed. All right, let's look further into the promise under some of the key comments under the restatement here. We have the manifestation of intention, key term. It adopts external and an objective standard. There's an external expression versus undisclosed intention. However, that external expression is what's going to stick. For interpretation rules, see that. We did a whole live stream on this, so you can go back and see that in the playlist. Then there's C, the promise of third person action. Words may promise a third person's action. It's commonly understood as the promisor's promise to bring about result. See, it's a promise of an action, but it's understood as a promise to bring about result by the promisor. An example is the guarantee of a third person's performance. So, the promise of event beyond human control, the warranty. We have a guarantee, surety, and warranty. Words promising events not within human control may include promise to answer for harm if the event fails to occur. An example, a warranty that a horse is sound, or a ship arrived previously. In insurance, warranty by insured is usually not a promise, but a condition of insurer's duty. This is the difference between a surety, where it's not conditional. Warranty is conditional in most cases here. In sale of goods, warranty normally includes a promise to answer for damages under the UCC, the Uniform Commercial Code, which has a lot of provisions in here for contracts. All right, let's look at some of the key comments on E through F under Section 2 of Promise from the restatements. E, illusory promises, mere statements of intention. Words making performance entirely optional with promisor do not constitute a promise. It needs to be specific. Reservation of option to change intention equals no justified expectation of performance. So when you reserve an option to change an intention, there's never been a manifestation of intention. There is no justified expectation of performance. And this expectation of performance is what drives it. But a conditional promise is still a promise, even if a small likelihood of duty is arising. Example is a promise to ensure thoroughly fireproof building is still a promise. So there you go. A thoroughly fireproof building, it's still a promise. So we have F, the opinions and predictions. The promise must be distinguishable from opinion or mere prediction. Then we have the Uniform Commercial Codes here. Its seller's opinion alone does not create a warranty. So the seller's opinion He says, I think it's the best thing ever. That does not create warranty. Also, buyer's reliance on seller's skill may create implied warranty of fitness. Ooh, on seller's skill. And then expert opinion paid for likely includes implied promise of reasonable care and skill. Of course. Why would an expert do anything other than that? All right, let's look at some of the illustrations now from the restatements on Section 2 of 4, promise. Here is the warranty of events beyond human control. So we have Party A, the builder of a house, or the inventor of the material used in part of its construction. Wow. Is he making some kind of geodesic dome or something? Says to Party B, the owner of the house, I warranty that this house will never burn down. This includes a promise to pay for harm if the house should burn down. Look at that. That's the warranty of event beyond human control. So he warrants that something beyond human control, the house burning down, he's promising it won't. This is a promise to pay for harm should the house burn down. Key points are the builder inventor warrants the house will never burn. He said this, I warrant this house will never burn down.
Bill Thimet 4426 says, if the igloo melts, does that count?
It depends what he said. Again, even if it's fireproof, and it truly is fireproof, he promises it'll stand. It's still a promise. And I guess same thing if it's going to melt, and he promises it's as long as he says it's going to melt and it melts. I guess it would depend. If he says it won't melt and it melts, then that wouldn't count. But if it melts and he implied that it would not, then that's an issue. So let's continue on here. The warranty includes a promise to pay for harm. That's what a warranty is, a promise to pay for harm. Warranty equals a promise to answer for harm if event fails. So really, the promise to pay needs to be proven. It's a promise to answer, I guess, more specifically in a legal context. So this includes the promise to pay for harm if the house should burn down. And if it melts, if he warrantied it, then they're back there with blocks of ice building a new igloo. Let's move on to illustration 2. The warranty of past facts in charter party. Party A by a charter party. So they get a charter here that undertakes the good ship Dove. So the good ship Dove is being chartered, having sailed from Marseille a week ago for New York. And it shall take on a cargo for Party B on her arrival in New York. The statement of the quality of the ship and the statement of her time of sailing from Marseille include promises to pay for harm if the statement is untrue. So this is the warranty of past facts in the charter party. So the charter party says all this stuff. They promise to pay for harm if these statements are untrue. So they're promising that it'll get to New York and all these things will happen here. It sailed a week ago. So the charter party for a ship Dove. It states the ship sailed from Marseille a week ago. The statements of quality and sailing time, right, and the past facts are warranted as if the promiser could cause them. So whether they're in control of those, he's standing there as if promising to pay for harm should they be untrue. So there's your warranty. And here's our third illustration, the conditional promise versus illusory promise. Ooh, boy. So here we have Party A says to Party B, I will employ you for a year at a salary of $5,000 if I go into business. So there's your condition, if I go into business. This is a promise, even though it is wholly optional with Party A to go into business or not. So the key points here are that if Party A offers employment, if Party A goes into business. This is the main part here, the main condition. Whether Party A goes into business is wholly optional. The condition depends on the promisor's choice, but it's still a promise. It's a conditional promise. It's not an illusory promise because it's still a promise. If he does go in, the condition still stands. So It will still be a promise. And our fourth illustration here is opinion versus promise. Party A, on seeing a house of thoroughly fireproof construction, says to Party B, the owner, "This house will never burn down." Party A, on seeing a house of thoroughly fireproof construction, this is his opinion. He says to Party B, the owner of the house there, "This house will never burn down." This is not a promise, but merely an opinion or prediction. If Party A had been paid for his opinion as an expert, there might be an implied promise that he would employ reasonable care and skill in forming and giving his opinion. So I'm an expert on this. Don't be careful saying that with your opinion. Party A sees fireproof house, states it will never burn. No consideration for Party A's statement. He just says his little piece, and there's no consideration for that. This is merely an opinion, a prediction. If, though, he was paid as an expert, there would be an implied promise of reasonable care, that duty. The gratuitous opinion, though, is not a promise. Right, now we're on to section 3. We get through the promises. We're on to section 3 with agreements defined and bargain defined. An agreement is a manifestation of mutual assent on the part of two or more persons. And then there's a bargain. It's an agreement. So this is a type
Bill
of
Thimmet 4426 says, salesmen are allowed puffery. They may overstate their products.
Indeed, to a certain extent, until they start making promises of usually it's a quantity of value or such degree of things. Once it can be quantified, it starts to go beyond puffery. But yeah, they are allowed a good range of opinion. Remember, this has to be opinion when there's no promise implied. So there's the big difference there. Now what we're looking at here is the, get back here, the agreement. So the agreement is a manifestation of mutual assent, but a bargain is an agreement, it's a type of agreement, to exchange promises. We're back to the word promise. Or to exchange a promise for a performance, or to exchange performances. So a bargain is an exchange. It's an agreement to exchange. It can be promises for promises, promises for performance, or performance for performance. The agreement is just the manifestation of mutual assent on the part of two or more persons. Now, a lot of people have thrown around the phrase meeting of the minds. There is no meeting of the minds defined in law or in the restatements. The closest you're going to find to that is right here, an agreement. It's a manifestation of mutual assent. That's your meeting of the minds. Because even if you weren't implying, if you were thinking something different in your mind, right? Only what's expressed is part of that manifestation. So if it's not expressed or directly implied somehow else by reasonable expectations, then that wouldn't be part of the agreement. It wouldn't be considered a true meeting of the minds either. But to be more formal, the term is a manifestation of mutual assent. So just to clarify that, because I hear a lot of confusion that goes on with this meeting of the minds, and it's used in a lot of legal texts, but you won't find it in any of the black letter law, so to speak, nor will you find it in the restatements as far as I've found. Definitely not in the restatements. I don't know about any of the other black letter so-called law, as that's also another term of art. Nevertheless, I just want to make that clarification. If you're looking for anything close to that meaning of the minds, you'll find it right here in Section 3 agreement in the manifestation of mutual assent, and we'll find some other finer definitions as we go along here. All right, so let's look at the key distinctions here. An agreement has a wider meaning than contract or bargain. There's no implications of legal consequences. I agree to this or that has no implication of legal consequence. A bargain is narrower, though, only applicable to exchanges. So the agreement doesn't have a necessary exchange, but a bargain does. It includes non-contract transactions, bargains. The contract is not necessarily a bargain. An example given here, a promise to make a gift under seal.
Minecraft Fafo says, smash up the like.
Yes, indeed. Please hit the like. All right. And indeed. All right, let's get that off. There we go. All right. So the manifestation of assent may be by words, conduct, or even silence. We spoke about this, where silence becomes assent, but only under certain conditions.
JKDX7X says, tribe.
Yes, thank you. And salute to all you for being here, because this is something that touches all of our lives' contracts, and in so many ways. And we see these varieties here and the ways they're implied and expressed. And again, the silence can be assent, but only typically if it's by the silence by the one making the contract says, well, if I'm silent, then I will accept, that kind of thing. It's really hard to do an acceptance with silence unless it's already implied that the silence means acceptance. Silence in and of itself usually isn't enough. But the manifestation of assent may be by words, conduct, or even silence. So 3 ways here to have that manifestation of assent, or as some would say, meeting of the minds. But not by your internal thoughts. That doesn't count. All right, section 4, how a promise may be made. What'll happen here? All right, a promise may be stated in words, either oral or written, or may be inferred wholly or partly from conduct. So we have express versus implied contracts. So there's no difference in the legal effect. As we saw before, expressed or implied, it doesn't really matter in terms of legal effect. The distinction lies only in the mode of manifesting the assent. As long as it's one of the acceptable forms of manifesting assent, then it is legal in effect. The assent may be by words, conduct, or silence. There's your 3 ways of assent, or your so-called meeting of the minds. The intention may be inferred from circumstances. So our conduct here. Course of dealing, usage of trade, especially when it refers into the Uniform Commercial Code. There are certain customs and usages that imply and give presumption to a lot of these stages here of expressing or implying a contract, acceptance, etc. All right, let's proceed here to the B here, comment B on the quasi-contracts distinguished. Quasi-contracts are different from implied contracts. They're not based on apparent intention. The obligations are created by law for reasons of justice. And that's under the restatement of restitution. We got into the quasi-contracts too, and I believe the first series in this playlist here on contracts, which is specifically called Defining Contracts, I believe. But we went into this a little bit more detail. Let's proceed. So, under our first illustration for section 4, let's look how promise may be made with implied promise by conduct. Party A telephones. Telephones. Party A telephones to his grocer. Send me a 10-pound bag of flour. The grocer sends it. Party A has thereby promised to pay the grocer's current price, therefore. Party A telephones a grocer to send flour. The grocer sends it without express price agreement. There's no written or oral promise to pay, but the promise to pay current price is implied from the conduct. This is a standard, reasonable way of doing business. That's why. So there's your implied promise by conduct. Good illustration there from the good old days. Let's look at a second illustration. Here's a promise inferred from nonverbal conduct. So, party A, on passing a market where he has an account, sees a box of apples marked 25 cents each. Nice market. Party A picks up an apple, holds it up so that a clerk of the establishment sees the act. The clerk nods, and A passes on. A has promised to pay 25 cents for the apple. Man, the good old days. Key points here is party A picks up an apple marked 25 cents each. He holds it up so the clerk sees it. The clerk nods. Party A passes on. No words were spoken. The promise was inferred entirely from non-verbal conduct. And they want to put a chip in people's head to be able to do this? It seems like it was already worked out. Let's move along. All right, now we get to the quasi-contract versus a true contract. Party A's wife, Party B, separates from Party A for justifiable cause, and, in order to secure necessary clothing and supplies, buys them from Party C and charges their cost to Party A. Party A is bound to pay for them, though he has directed Party C not to furnish his wife with such supplies. But Party A's duty is quasi-contractual, not contractual. See the restatement of restitutions. All right, so we have key points. Wife separates for justifiable cause, buys necessities from Party C, charges husband Party A. Party A directed Party C not to furnish supplies, but Party A is still bound to pay because the duty is quasi-contractual, not contractual. So through that duty, there's a quasi-contract, which is enforceable by remedy through different legal means. And now we're on to Section 5. Terms of promise, agreement, or contract.
Bill Thimmet 4426 says in an auction, a very subtle gesture can count as a bid.
Exactly, and that's the whole point, is that we have different ways of doing nonverbal acceptances and such, and this is the way the world pretty much has worked for quite a while. Some of these things we're going over here seem they should be common sense, but I digress. Let's proceed here. We're on to Section 5 here, the terms of promise, agreement, or contract. Number 1 is the terms of promise agreement. That portion of the intention or assent manifested which relates to a particular matter. So the terms of promise relates to a particular matter, particular. So a particle, something specific, separated from the others, relates to a particular matter. And it's the assent manifested which relates to that. The terms are that portion of the intention or assent manifested. Now we get, that's the term of promise. We're talking about terminologies and other terms. We're talking about the term of promise, and that's a portion. So we get term of contract, and it's that portion of the legal relations resulting from the promise, which relates to a particular matter. That's the subject matter, or usually our consideration here, whether or not parties manifest an intention to create those relations. So the term of the contract is the portion of legal relations. This is whether or not the parties manifest an intention to create those relations. So understand this. Those relations are created irrespective of the intention of assent. So this relates to a particular matter and whether or not the parties manifest an intention to create those relations. So that's term of contract, terms of promise. Two different assents manifested. Or one's an assent manifested, one's an intention to create a relation.
Says Blessings Tribe finally caught alive.
Excellent, and greetings to you. This is a good one here. Contracts applies to everyone, as I was saying. And stay to the end because we're going to have a very special treat at the end here. So let's proceed. Let's go first. The key points here. Oops. Let's get back there. So our key points is agreed terms, the expressed in the language or implied from the conduct, as we saw with a nod, It's understood in the light of the circumstances. The nod wasn't from some random passerby, or the nod was from a guy that they recognize as having an account there. And any reasonable person would know that he's not just stealing an apple, that he's intending to pay for it through his account, and they recognize him through the nods, the mutual nods and assent. So B is the contract terms are supplied by law. Rules varied by agreement or often rest on public policy. And the statutory contract terms. These were our formal contracts. They vary in extent of permitted variation. For example, given here, we have the Uniform Commercial Code 111023 versus prescribed insurance forms. So, on the extent for statutory contract terms. So, again, the type of contract, formal or informal, will depend on whether some of these terms apply in that context and to that extent. All right, now we're on to illustration 1 for the terms of contract. We have statutory terms override express exclusions. Exclusions. All right, so our express exclusions, the statutory terms are going to override those. So Party A contracts to sell Party B a described automobile. Both parties signed a printed contract form on which the description is typed and which contains the printed words. Seller hereby excludes all warranties, express or implied. Under the Uniform Commercial Code section 2316, the quoted words do not exclude an implied warranty of merchantability. And under section 2314A, 314, Party A warrants that the automobile is fit to drive. Under section 2714, the warranty has the effect of a promise to pay for harm if the warranty is broken. Oh man, so the statutory terms, because he's involved in that commerce, right? Party A sells the automobile to Party B. The printed form excludes all warranties, but under section 23106, exclusion is ineffective for merchantability, meaning to be able to sell it in the market as is. And the warranty, the car is fit to drive, that's also implied, whether it's they cannot exclude it. The statutory terms override the express exclusions. So even writing in exclusions, if it's under a statutory sale, which this one seems to be, then the Uniform Commercial Code, which is codified in
Sawyer Stash says, "Oh, Walters, it is almost like a real-time present value contract."
on this one here, I think what we're implying here is that this is anytime you try to express an exclusion, to exclude something that should be a right or a duty for you to perform, that would not be, it's overridden by statutes if it's a formal contract. This one here,
Noifaka News says, "Yeah, I am so glad I caught him live."
Excellent. I'm glad you're here too. All right, so what we're looking here is at the fact that this contract, we're kind of assuming that it's a formal contract. Therefore, it's the statutory regulations apply to it. And that's why we're bringing in Uniform Commercial Code into this transaction, because it's a formal contract. So the statutory terms override the express exclusions. So that's this case. This is a case here in this illustration where the statutory terms would override any express exclusions. So these are pointless to have these exclusions in here. Seller hereby excludes all warranties express or implied, because under the Uniform Commercial Codes, which are adopted into state statutes in all 50 states, then they would override those exclusions he's trying to put in there. So if you were the buyer and for some reason it wasn't merchantable or it wasn't drivable, you would have recourse, legal recourse. All right, now we're on to formal contracts. These are the types subject to special rules. So, of course, the most famous is the contracts under seal. Rules in Chapter 4. Many states have modified or abolished seals by statute, though. This is old school contracts. UCC 2203, goods contracts not under seal, even if affixed. So it's kind of presumed to be under seal once signed. They say signed, sealed, delivered. Not all those are necessarily required anymore. Then we have B, the recognizance, acknowledgement in court that recognizer is bound to make payment unless condition is performed. It's used for court attendance, prosecution, or bail. So the recognizance, right? These are the types that are subject to recognizances. These are contracts or acknowledgement in court that the recognizer is bound to make payment unless a condition is performed. So if they don't show up, they're going to make a payment. Used for court attendance, prosecution, or bail. Then there's C, the negotiable instruments, documents. Drafts, notes, bonds payable to bearer or order, warehouse receipts, bills of lading. These are subject to Uniform Commercial Code Articles 3, 7, and 8. Negotiable instruments, documents, eligible papers. And then D, letters of credit. Promise to honor drafts within scope of UCC Article 5. No consideration is necessary to establish. It's related to the law of negotiable instruments. So these are contracts such as letters of credits, negotiable instruments, recognizances, and contracts under seal. These are all subject to special rules that fall outside the historical rules of contracts. But these are included in the restatement just to make it clear by our good friends at the American Law Institute with their such generous contributions of their legal prowess to bring us this type of documentation. Okay, Section 7, voidable contracts. A voidable contract is one where one or more parties have the power by a manifestation of election to do so, to avoid the legal relations created by the contract, or by ratification of the contract to extinguish the power of avoidance. So both ways here. So the voidable contracts we were seeing before about the relations created. So was there intention for relations created, and were they legal? So grounds for avoidance. Okay, this is ways you could avoid the contract or void. One party was an infant. So the baby, the footprint on the contract doesn't count. Fraud, mistake, or duress. Those are grounds for avoidance, voiding the contract. These are voidable contracts. Breach of warranty, justifying termination. Both parties may have power if both infants or mutual mistake. Jeez. So don't let the babies play with contracts. Of course, you know this term infant, what this really means is they haven't reached the age of majority, so to speak, and it's the infant estate that they're not able to have full control over. Nonetheless, I digress. Here are the consequences of avoidance, too. It may be entitled to restoration to prior position, though. It may be left in condition at time of avoidance. The action may be needed promptly to prevent ordinary legal consequences. So the note here is void contracts equals no contract at all under Section 1 or the definitions. Because if it's a void contract, it didn't meet all of the necessary conditions for definition. All right, so we're on to voidable contracts here. Let's see, did we get everything on this slide here? Yes, indeed. So the voidable contracts, here's our fourth illustration here with the key points in our fraud-induced promise. Here's where it's voidable, not necessarily void. Party A, by fraud, introduces party B, induces party B to promise to pay for certain advice which party A gives. Wow. So party A is fraudulently inducing party B to pay for certain advice or promise to pay. This promise creates no duty in party B, but is not wholly void because it can be validated by B after he learns the facts. So, Party A induces Party B's promise by fraud. The promise creates no duty in Party B, but it's not wholly void because it can be validated after Party B learns facts. So it's voidable, ratifiable. It's not necessarily void. So depending on if it can be validated after Party B learns facts. All right, we're on to Section 8, unenforceable contracts. An unenforceable contract is one for breach of which neither the remedy of damages nor the remedy of specific performance is available, but which is recognized in some other way as creating a duty of performance, though there has been no ratification. All right, here's our key distinctions and types. We have distinguished from voidable because the duty does not depend solely on the election of one party. There are some legal consequences that follow without further action by either party. Here are our types. We get illegal bargains. Illegal bargains. They're neither void nor voidable because they're illegal. The statute of frauds. We have statute of limitations. Then there's government contracts. There's sovereign immunity may bar suit, but obligation is still recognized. So it may be a write-off as a loss. There's many different reasons why. Let's move along here. Now we're on to the unenforceable contracts. Here's voidable and unenforceable, the distinct offenses. Party A, an infant, orally accepts a written offer signed by Party B. You realize when I say infant, we're not talking about a little baby. We're talking about someone that's has an infant could be someone that's not able to speak for themselves. They need a guardian, or they need some type of someone else has a power of attorney for them to be as their agent here. But Party A, an infant, orally accepts a written offer signed by Party B, an adult, to sell a tract of land. Party A's promise is voidable by him because of his infancy and unenforceable under the statute of frauds. Upon attaining his majority, Party A delivers to Party B a signed writing stating the terms of the contract and manifesting an election to avoid it. Under Section 133, the statute of frauds no longer prevents enforcement, but the contract is avoided. So that's a pretty interesting take on it here too, the voidable and unenforceable. So if an A accepts adult Party B's land sale offer, it's voidable, the infancy, and unenforceable because of the statute of fraud. So two reasons why the contract is unenforceable and voidable. Party A attains majority, then signs a writing. The statute of frauds could be cured by the writing, but Party A elects to avoid because the contract is voided. There's two distinct defenses. So as you see here, wow. Two different points here, voidable and unenforceable. So there's two distinct defenses. So don't get into contracts with infants. And here's unenforceable contracts and statute of limitations as barred but not extinguished. So Party A is indebted to Party B, but the statute of limitations has barred a direct remedy. Party A has the power to make direct remedies available or to make a new contract without consideration by making a new promise or part payment of the debt. See Section 82. Even without such further acts, legal consequences may flow from the barred debt. If the creditor has security, he may have a right to apply it towards payment of the debt. So this is where the statutes of limitations come into play here. And the direct remedies or to make a new contract without consideration by making a new promise or part payment. So we get a novation. The novation in this case would essentially make void or discharge the previous contract and it would actually make it so that the new contract terms would now take effect, and there would be no further duty or debt to the original party. So if the creditor has security, he might have the right to apply it towards payment of the debt. So party A is indebted to party B. The statutes of limitation bars direct remedy. However, party A can revive by new promise or part payment. Creditor with security can apply it. So the barred debt still has legal consequences. And of course, that's renegotiated there. Now we have the public policy, unenforceable while executory. Party A agrees to sell specific goods to Party B. Party B agrees to buy them. Party A has previously contracted to sell the same goods to Party C, as Party B knows. The bargain between A and B is unenforceable on grounds of public policy, Section 194, and neither party can enforce it while executory. What does executory mean in a contract? It means it still has not been fully executed. So there's still not every exchange has been completed, not every consideration and value exchange, etc. It's just been agreed, signed, and it's in process, so to speak. So neither party can enforce it while it's executory. But if either party performs his promise, he can recover what he has transferred or its value. The return promise, though unenforceable, is given legal effect as showing that the performance was not gratuitous and is therefore a contract. But of course, that's going to be limited to the cost, really, not the full value in most cases. So we have here Party A has already contracted to sell goods to Party C. Party A agrees to sell the same goods to Party B, and Party B knows it. Says, "Come on, sell it to me instead," right? Well, that is going to be unenforceable, and if performed, it can recover value that transferred. So the promise shows performance wasn't gratuitous. So the promise is the key. The performance is the key. All right. Now we're on to the fourth illustration of unenforceable contracts. Here we have collateral legal effects despite the unenforceability. And make sure you stay tuned. We're almost to the end here. We're going to get to the best part of the whole presentation with a special treat. So, Party A makes an oral purchase of goods from Party B for an agreed price of $500. There's no delivery or part payment, and the bargain is unenforceable under the statute of frauds. Party A insures the goods as owner. The insurer cannot defeat a claim under the policy on the ground that Party A did not own the goods, although Party A would have had no direct remedy against Party B for failure to deliver. So, key points here is that Party A makes an oral purchase for $500. There's no delivery or part payment. It's unenforceable under statute of frauds. Part A insures goods as owner. The insurer cannot deny ownership. So the collateral effects despite enforceability. So Party A makes the oral purchase from Party B. There's no delivery or part payment. But A insures the goods as owner. The insurer cannot defeat a claim under the policy on the ground that A did not own the goods, though A would have had no direct remedy against B for failure to deliver. So what this really means is that the insurer would have to go after Party B because they have an agreement here and it wasn't met, and A insures the goods. So, wow, that's a pretty good one there. And here's another unenforceable contract, sovereign immunity, defense use permitted. All right, Party A, an American citizen, holds notes issued by Party B, a foreign government. Because of the sovereign immunity of Party B, the foreign government, the notes are not enforceable against Party B in the courts of the United States. In an action by Party B against Party A on an unrelated claim, however, Party A may use the notes as an offset to reduce the amount of Party B's recovery. Wow, so it could be recognized in another case, but you can't use those notes. They're not enforceable as themselves, but they can be used to offset or reduce an amount of another recovery. Party A holds notes from a foreign government B, unenforceable due to sovereign immunity. But if Party B, the foreign government, sues Party A on an unrelated claim, Party A can use those notes as an offset. The defensive use permitted despite unenforceability. Hey, that's a pretty good angle there, huh? And a sixth illustration for unenforceable contracts. And this should take us to the end of Section 8. The government contracts, judgment, and tax consequences. Oh boy. Nothing here is to be used or misconstrued as tax or financial or governmental advice. Party A, an American citizen, has a contract with the United States government, and after a breach by the government, obtains a judgment for damages in the United States Court of Claims. Under the tax laws, money receivable under the contract is taxable as accrued income when there is a reasonable expectancy that the right will be converted into money. Let's see, the right of the judgment will be converted into money. You see this? So this is saying that a judgment for damages, follow here, a judgment for damages will be converted into money. That they have a reasonable expectation that that right, which is judgments or rights here, will be converted into money. The income accrues in the year in which the time for the appellate review of the judgment expires, even though the Congress does not appropriate money to pay the judgment until the following year. So they're working on the accrual method of accounting, not the cash in, cash out method that most are accustomed to. And that's how they do this. So this is high level here, and that's why we saved it for last. So Party A has a contract with the U.S. government. The government breaches a contract. Party A obtains a judgment in their favor. The income is taxable when reasonable expectancy of payment or conversion into money. It accrues when the appellate review expires, the income tax. So after the appellate review time expires, that's when it becomes, starts accruing at that billing period, even before Congress appropriates funds. So even before you get the money, it appears on the books. The judgment creates the taxable income. Of course, wow. But that tells you onto a key point that the judgments are property or rights to property. They have property rights associated, and they can be converted to money. And in some cases, they could be considered, these terms of art here, taxable income. Wow, so pretty good stuff. And in summary, the contract is promise or promises, set of promises, with legal remedy or recognized duty. So these are the key factors here to keep track of. Promise, a manifestation of intention, justifying commitment expectation. So the promise is what creates that expectation of a commitment, of a duty, obligation, payment, etc. An agreement is the mutual assent. The bargain is the exchange of promises and performances. The promise may be express, words, or implied, conduct even. The terms, agreed by parties or supplied by law statute. Then there's formal contracts. These are the ones that are sealed, recognizances, negotiable instruments, letters of credit. These are all the statutory types of contracts under those rules. Then there's voidable. The power to avoid exists, especially when dealing with infancy, fraud, duress, or mistake. Those are voidable contracts. Or unenforceable. There's no direct remedy, but duty is still recognized. All right. That takes us to the best part of the presentation for those of you that stayed. It's we're going to have the fun contract terminology quiz. Now, here's how we play this game. We start with the question number. You put in the chat the number of the question you're answering and then the letter of the selection you choose. So for question 1, if I was going to select letter D, I would put into the chat Arabic number 1 followed by letter D delta, and that'd be my choice. If I need to change it, I would just put that same question number in again with a different letter choice, and then the last one will be considered your final answer. We'll tally up at the end and test your knowledge. Let's get started. So question 1. Party A and Party B have an oral agreement for sale of
Sawyer
land.
Stash says 1. C.
Okay, but I haven't read the question yet. All right, but we get you down for C. So Party A and Party B have an oral agreement for sale of land. Party B pays Party A $1,000, but the agreement is unenforceable under statute of frauds. However, the law grants Party B a right to restitution of $1,000 if A refuses to convey the land. Under the restatement, is this agreement considered a contract? Answer A, no, because the agreement that is unenforceable cannot be a contract. Is it B? Because the statute of frauds renders agreement void of legal effect. Is it C? Yes, because the law indirectly recognizes a duty to perform through right to restitution. Or D, yes, because oral agreements are always considered contracts, regardless of enforceability. All right, so we have one answer for C. Any other answers anyone wants to make before we go on to the next question? Any other takers? Going once, going twice. Question 2. A builder says to a homeowner regarding a fireproof house, I warrant that this house will never burn down. If the house eventually burns down, what is the legal nature of the builder's statement under the restatement? Is it A, it is an illusory promise because the builder cannot control the event of a fire? Is it B, it is a mere opinion or prediction as no one can guarantee future
News
events?
says capital C.
All right, we have C. That's I take for number 2. Go ahead and clarify in the chat if that's for number 2, because letter C is, it is a promise to pay for harm if the event fails to occur, a warranty. Or is it D, it is a quasi-contractual obligation imposed by law, not a promise. All right, so we had a C for question 2 as well. So we had one for question 1C, one for question 2C. Let's move on to question 3. Any other takers here for question?
Bill 4426 says 2B.
2B is a mere opinion or prediction, as no one can guarantee future events absolutely. All right. Let's move on to question 3. Come on. Party A's wife separated from him for just cause. Then she buys necessary clothing from a local store and charges them to Party A's account. Party A had previously explicitly told the store not to supply his wife. Despite this, Party A is legally bound to pay the store. What type of obligation is this? A, an express contract because A is bound to pay for necessaries. B, an implied in fact contract based on the apparent intention of the parties, implied in fact by their behaviors, kind of like the head nod.
News says capital D.
And we have a D, and I take that's for question 3. Well, C is a voidable contract because A can disaffirm the wife's actions. Or D, a quasi-contractual obligation created by law for reasons of justice. So we have a D for this one here. Any other takers for question 3? Going once, going twice, going 3 times. We're on to question 4. Which of the following?
Sawyer Stash says 3D.
All right, we have another one for 3D. Just for clarity, that's the quasi-contractual obligation. 2 for 3D. All right, let's move on to question 4. Which of the following statements accurately distinguishes an unenforceable contract from a voidable contract?
News says capital B.
All right, so we're on to, I take it that's for question 4.
News says 3B.
Okay. And just for clarity, 3B is an implied in fact contract based on the apparent intention of the parties when the intent is legally bound to pay for the store. All right, let's get back to question 4. Which of the following statements accurately distinguishes an unenforceable contract from a voidable contract? So unenforceable or voidable. We saw one where they could be both. But what's the accurately distinguishes them? A, an unenforceable contract allows a party to avoid legal relations through ratification, whereas a voidable contract is void from the start. Is it B, an unenforceable contract is one where direct remedies are unavailable, but a duty is recognized, example given here for set-off, whereas a voidable contract is subject to a party's power of avoidance? Or is it C, an unenforceable contract involves illegal bargains, whereas a voidable contract only involves minors? Or is it D, an unenforceable contract requires a seal, whereas a voidable contract requires a writing? So I think you can clearly see it's going to be one of the first two here, more than likely. Let's look at it a little bit more closely. Which is the most distinguishing factor here? One allowing a party to avoid relations through ratification, whereas a voidable contract is void from the start, or this one here?
Bill Thimis 4426 says 5A.
5A? You mean 4A, right? We don't have a question 5
Bill
yet.
Thimis 4426 says 4A rather.
Okay, yeah, all right. So we get A.
Sawyer Stash says 4A.
All right, we have 2 for 4A. That.
Noit Fakanu says for A.
All right, so we get 3 for A. So let's just move on to the answer slides now. And for question 1, the oral land agreement was enforceable under statutes of frauds, but B was unenforceable, but B has a right to restitution. Is it a contract? And the answer was C, yes. Because the law, this is what we mostly got here. I think we all got C correct on question 1. Yes, because the law indirectly recognizes a duty to perform through a right to restitution. So that's what the law recognizes, that duty, and you have a right to restitution. So it's unenforceable under statutes of fraud, but B has a right to restitution. All right, on to question 2. The builder warrants a fireproof house will never burn down. Why is this statement legal nature? Well, it's because it's a promise to pay for harm if the event fails to occur. That's a warranty. See, now on section 2, it's comment D explains that words promising an event beyond human control are interpreted as a promise to answer for harm caused by the failure of that event. It's not saying that it can't happen, but if it happens, if it's caused by forces beyond their control, they're still going to answer for that failure and provide for pay for that harm. So there it is. And again, on the question for question 1, just to clarify, we get this one right here for C, but it states a contract is a promise that the law recognizes as a duty. Comment E from section 1 notes that even if direct remedies are barred, indirect recognition like restitution makes an agreement a contract. All right. And on question 2, that was a little bit more difficult because we had the distractor of letter B, but letter C is correct because remember, he's an expert. He's the builder. It's not his opinion. He warranted. He says, I warrant that this house will never burn down. All right, we're on to question 3. The wife buys necessaries charged to party A's account. Party A told the store not to supply her, but they did. What type of obligation is this for him to still pay? And the answer is D. So we get that one right here mostly. And that was the quasi-contractual obligation created by law for reasons of justice. Remember, that's something where they're separated. So really, he's still responsible for necessaries. This is the key. They're necessaries. She's not out there buying, jewelry and stuff. These are necessaries, clothing, right? That's essential. So comment B distinguishes quasi-contracts, obligations created by law for justice, not based on intention or promises, from implied in fact contracts. The specific illustration confirms this is a quasi-contractual. All right, and finally on to question 4. Question 4 was a very tricky one here. Which of the following statement accurately distinguishes an unenforceable from avoidable contract? And it was actually B, because the unenforceable contract is one where direct remedies are unavailable, but the duty is recognized. Example given here for set off, where avoidable contract is subject to a party's power of avoidance. Remember the relations. So Section 8 defines an unenforceable contract as lacking direct remedies while recognizing a duty, where Section 7 defines a voidable contract as one where a party holds a power to avoid legal relations. So think of this, the difference. One's lacking direct remedies while recognizing a duty. The other is a power to avoid legal relations. So unenforceable, it's lacking direct remedies while recognizing a duty. So it's unenforceable. There's no direct remedies. While voidable means that a party holds a power to avoid the relations, the legal relations set up in the contract. So that's the big one there. And I guess you could remember this by knowing that unenforceable means there's no remedy in law, and voidable meaning that it was never, the legal relations can be avoided. All right, well, with that, that takes us to the end of this presentation here, and a pretty good long one at that. So salute to you all that were able to stick through it to the end here and participate in the little quiz. Now, again, those quizzes are pretty hard. This is something that you'd be doing at first year law school anyways, and who knows if the questions would even be such as this. I try to keep them very true to the text and also a little bit applicable to our daily lives, so we could kind of feel where the rubber meets the road in learning all these types of terminologies and legal stuff that really is just there to smooth out the disputes. So with a firmer understanding of these things from their foundations, I think that really is a better way to avoid disputes and avoid all the legal entanglements that come with that kind of misunderstanding. So I think the better we do this, it's a rising tide to raise all boats.
News says, thank you, that was fun.
Indeed, and it's been fun to participate with all of you here, and I hope you all do hit the bell to subscribe for any of the upcoming live streams. I try to keep this interactive, and frequently we get some pretty good attendees, as we've had tonight too, that have a lot of good input here. It really helps us keep thinking more about the subject matter and actually where it applies and has a little bit more meaning in our lives as far as getting the best benefit we can from the society we're living in. And again, it's over litigious at some points, but understanding where.
Strognock says, always good info.
Well, thank you. And indeed. Well, on that said, I would like to invite you all to subscribe and make sure you hit the bell notification to come in the next one.
Sawyer Stash says, thanks the tribe.
You're very welcome, and I hope to see you all on the next one. Peace out.
Nightfackin News says, when will you be back? Bill Thimmons 4426 says, take care all. The tribe says, perhaps tomorrow. The tribe says, although tomorrow is promised to no one. Nightfackin News says, capital K.